have a final overtime rule, finally. Hi, I'm George Whipple. On September 24th, the Department of Labor issued a final rule increasing the annual salary threshold for white-collar exemptions to $684 per week. This is an increase of about 50% over present levels. Up to 10% of that amount can be in the form of commissions, non-discretionary bonuses, or other incentive compensation. For highly compensated employees, the final rule increases the annual earnings threshold to $107,432. The new thresholds will take effect January 1st, 2020.
One of the big issues going into this rulemaking was whether there would be automatic increases of these salary and compensation levels. In the Obama administration's proposed rule and final rule that ended up not going into effect, there was a provision calling for automatic updates without new rulemaking every 3 years. The department considered that type of commitment in its Notice of Proposed Rulemaking that it issued in March of this year, but chose not to have automatic updating in the final rule.
The ABC test becomes law in California. Last month, California passed legislation codifying the worker classification test established in the state Supreme Court's Dynamex case. The new law goes into effect on January 1st, 2020, and will likely impact a number of industries. Under the new law, individuals hired to provide services will be considered employees unless the hiring entity proves that the individuals, A, are free from direction and control, B, perform work that's outside the usual course of the hiring entity's business, and C, are engaged in an independently established trade, occupation, or business. While versions of the ABC test are already used in several states in some circumstances, California has set a new high watermark, with some other states already signaling that they may follow suit. The pay data collection story took another turn in September. After much legal wrangling, the EEOC is still collecting the Component 2 pay data from 2018 and 2017, which was required to be submitted by employers by September 30th. But for now, the agency has announced it does not anticipate renewing the pay data collection requirement moving forward, including for 2019 data. The agency underestimated the compliance cost of yearly submissions for employers.
The EEOC took a hard look at the data collection burden estimate that was done in 2016. In 2016, the EEOC decided that they were going to treat every employer the same. So whether you have a single establishment, which requires one form to be filed, or 150 establishments where you have 150 or forms or more to file, they treated everyone the same way. That is not an accurate representation of what the filing is. Likewise, it's a much more complex form that's being required. So for the EEO1, the standard EEO1 is 140 data fields. The new Component 2 data fields are 3,360 fields. So it's a much more complex report to file, and it's a much more expensive report to file.
And it was a summer to remember for the NLRB. With a Republican majority firmly in place, the board took on a number of contested issues over the past few months. Their decisions continue the NLRB's move away from the pro-union perspective of the Obama-era board, and, in some cases, reversed long-standing precedent.
The general impact of the Republican majority board decisions is really to slant the case law in favor of employers and the employer's position. They had three main decisions just this summer that really gave the power to employers to control. One was a UPMC hospital decision. One other major precedent that the Republican majority impacted was the standard applied when looking at unilateral change to bargaining terms. Now the board said, well, no, hold up, we'll wait. You know, if there's a management rights provision that really gave them the ability to do that, then we won't really look at clear and unmistakable waiver. That's also going to be the fight at the bargaining table in terms of making sure that language in the management rights clause gives the broadest width of action. This fall, we will most likely continue to see limits placed on ability to organize and case law that favors unions.
Thank you for watching. We'll see you next time.